request Justice Rajiv Shakdher and Justice Muralidhar to take the chair. So thank you for coming on time. We are punctual at 5 o'clock. We have started. And I have already sent message to them, to both the judges, that already more than that time, half an hour before, more than 50 advocates have already come. So thank you for their reputation. So your name still rejuvenates in the minds of the advocates, the way you have delivered the judgments at the Delhi High Court, as well as in Orissa High Court and Himachal Pradesh. Normally in the hall, it will be full of Gandhians, Sarvodayavadis, with white and white khadi. But this time, the hall is full of advocates. The first time in the history. So thank you for making this program to happen. And when we approached Justice Muralidhar and Rajiv Shakdher, both were out of country, but without hesitation, they have accepted immediately, and we have fixed this program. Only after coming back on 3rd or 4th, I sent the message to them officially. So, as a freedom fighter, we have read many things about Gandhi, his contribution in the freedom struggle. But we have very little knowledge about his legal profession. So thanks to both these judges, when they were the High Courts, the judges of the High Court, Delhi High Court, we have approached them. They approached us. We didn't approach. You approached us to celebrate Gandhi 150. First time in the history of Delhi High Court, we have organized a Gandhi program inside the premises of Delhi High Court. That is the great achievement. It is because of the judges like Rajiv Shakdher and our Muralidhar, both were there at this time. And it paved way to take that exhibitions in different high courts all over India. And we have also published as a book. Therefore, we thought we can also have some ideas of how Gandhi dealt the cases when he was a judge, when as a lawyer. There are in South Africa, I recently visited South Africa, even the Durban High Court, they didn't demolish the High Court. They have converted this Durban High Court as a museum. And he traveled in Durban through train from Durban railway station. Now they have constructed a new railway station, but they didn't destroy or distract or demolish that railway station, but made it as a museum. Even inside the campus, inside the Durban rail museum, railway station, they erected a Gandhi statue. But we have failed to remember the father of the nation and his contribution. Not only his contribution, there are lakhs and lakhs of people. They have contributed for the success of our freedom struggle. That local history we didn't capture and put it for the future generation. Therefore, it is right time for us to think upon the role played by Gandhi, not as a freedom fighter, but as a lawyer, when he was in South Africa and very briefly in India. I don't need to introduce the guest because he has already known to you all very familiar judges of the Delhi High Court. So I welcome both the judges and now Muralidhar as part of our Gandhian fraternity, from legal fraternity, he has become a part of our Gandhian fraternity. He is our trustee of Gandhi Smarak Nidhi. So on behalf of Gandhi Smarak Nidhi, Gandhi Peace Foundation and the National Gandhi Museum, I welcome both the judges as well as the advocates who have assembled here. So thank you, and I invite our Ramchandra Raji to honor our guest, Muralidhar. No, he will come. And Advocate Komal Vashisht and Ramit Shehawat. I request Ashok Kumar, Secretary of the Gandhi Peace Foundation, to honor Justice Rajiv Shakdher. And Farhat Abbasi and Advocate Vijay Kumar. So there are many people, they have helped us to organize this program and share the invitation to bring the advocate friends, Sri Vidyanandan, Rana, SP Singh, Vikas Sharma, Sunil Kumar, Udayveer, Ramit Shahawat, Farhat Abbasi, Vijay Kumar, Deepak Sharma, Bhavan Bahal, Satish Solanki, Rajiv Bola, Vivek Kumar, and other friends who have helped in bringing all of you here. And we are going to have a wonderful session with Justice Muralidhar. I invite our president of this function,
Dr.
Rajiv
Muralidhar,
Shakdher, to deliver
Justice
the presidential address.
My friend at the Delhi High Court, my friend and colleague who was with me in the Delhi High Court for nearly 8 years, if not more, Mrs. Tara Bhattacharjee, the chairperson of the National Museum, Gandhi Museum, Mr. Ramchandra Rahe, Mr. Ashok Kumar ji, and our very own Mr. Annamalai ji, the director. Distinguished guests, ladies and gentlemen, advocates, friends, it is indeed a privilege and a distinct honor to be amongst you all to converse about a man who changed the discourse on how oppressors should be dealt with. The life experiences that Mahatma had and the persons he met and interacted with, both friends and opponents, shaped his personality, glimpses of which we get from his own writings and those penned by others. My experiments with truth, the autobiographical account, gives us an unvarnished view into his life. He rose from an ordinary householder and a lawyer to become, in the minds and hearts of people, a saintly figure who was lovingly known as Mahatma, something that perhaps he did not like to be referred as. But Gandhiji at heart, and that's my view, was a karma yogi. This was evident even as a child. His sister Raliyat once said, when asked, Monia, which was Gandhiji's perhaps pet name, was restless as Mercury, could not sit still even for a while. I don't know how many of you know Restless as Mercury, Life as a Young Man is a title of the book edited by Shri Gopal Krishna Gandhi, Mahatma Gandhi's grandson. In Shri Gopal Gandhi's words, it complements Mahatma's autobiographical work, My Experiments with Truth. The lecture series on Gandhi's is perhaps, in my view, the best way to disseminate to the public at large the inspirational story that Gandhiji's life is. It is with this thought in mind, and this is important because Mr. Annamalai just briefly referred to this, that in 2019, I, along with Delhi High Court Bar Association, which at that relevant time was held by Mr. Mohit Mathur, Senior Advocate, Mr. Amit Sharma, along with Mr. Prashantu Sen and Mr. Anish Dayal, two of whom, as you know, went on or have gone on to adorn the bench, and one of them became a senior advocate. An attempt was made to refocus on that part of Gandhiji's life, i.e., the life as a lawyer, which, in my view, at times is lost sight of while emphasizing and talking about other milestones in his life. We took out a special edition of the Quarterly Bar Review, brought about by the Lawyers Association, which was devoted entirely to this aspect of Gandhiji's life. It carried Gandhiji's picture, which is in fact a part of a picture of a sculpture installed in his memory on the Church Street in Peter Marit's Marg in South Africa, and that is this picture which was on the Quarterly Bar Review. We also held an exhibition, which is what Mr. Annamalai was informing us about a while ago. The entire historical material for which was supplied by Mr. Annamalai ji. Shri Gopal Gandhi graciously agreed to speak at the function. Thus, to spread Gandhiji's message to the world, we also endeavored to communicate that through a play, the message that we wanted to convey, and something that I think as youngsters and in today's space and time we need to remember, is how to stand up against tyranny. We asked one of the most outstanding artists, Mr. Raina, to ask his troupe to perform the play which was based on the sedition trial of Mahatma Gandhi in March of 1922. I wonder how many of my young friends are aware of the fact that Gandhiji, including Bal Gangadhar Tilak, much earlier than Gandhiji, were charged under section 124A of the IPC for writing merely 3 articles in Young India magazine, which was published by one Mr. Banker. In fact, he was the co-accused in the case. Gandhiji, true to his nature, pleaded guilty as charged and asked the judge, who was an Englishman, Mr. Broomfield, to award him the maximum punishment. Gandhiji was awarded 6 years, which to my mind is not what defines the importance of that moment, but what he said and how the judge responded is worth recalling. Gandhiji made 2 statements. One was an oral statement, the other was a written statement. I'll just go through parts of that statement so that it stays with you, and this is something that is so important today as it was then when we were on the threshold of freedom or were attempting to get free from the British tyranny. He says, after the Advocate General for the prosecution had completed his statement, his opening statement, his statement as to why Mr. Gandhi had been charged, he says, and this was his oral statement, "I have no desire whatsoever to conceal from the court the fact that to preach disaffection towards existing system of the government has become almost a passion with me. And the Advocate General is also right when he says that my preaching of disaffection did not commence with my connection with Young India, but it had commenced much earlier." One can't have most accused expressed such candor in such difficult times. And then he read from his written statement, which is even more revealing and important. And I quote, Section 124A, under which I am happily charged, is perhaps the prince among political sections of India's penal code, designed to suppress the liberty of citizen. Affection cannot be manufactured, he said, or regulated by law. If one has no affection for a person or system, one should be free to give the fullest of expression to his disaffection, so long as he did not contemplate, promote, or incite violence. But the section under which Mr. Banker, which was the publisher, and I are charged is one under which mere promotion of disaffection is a crime. And then he goes on to say further, but I hold it to be a virtue to be disaffected towards the government, which in its totality has done more harm to India than the previous system. India is less manly under the British rule than she was ever before. Holding such belief, I consider it a sin to have affection for the system. It has been my precious privilege for me to be able to write what I have in the various articles tendered in the evidence against me. If I wanted to pause for a moment, and if one is exposed to the life experiences of Gandhiji, and I'm sure Justice Muralidhar will touch upon them, I ponder whether Gandhiji's statement at the trial had something to do with his tryst with Abdul Haji, the person who brought him to Durban to litigate against his own cousin, Tayyab Sheth, over money owed to him, and the incident when he was thrown out of the train at Maritzburg. Full stop. In the incident, he got exposed to what one would say, and this is his own words, the attributes of non-violence. The arbitrator before whom this case was contested ruled in favor of Abdul Haji and awarded him 37 pounds against a claim of 4,000 pounds. But Gandhiji prevailed upon his client to allow Tayyab Sheth to pay in installments. Gandhiji said when this occurred, I had learned the true practice of law to unite parties riven asunder. It is thus, in my opinion, important that we sear in our minds and hearts the lessons that Gandhiji imparted to fellow Indians during lifetime. There is, to my mind, no better way of doing this than to hold such lecture series. I congratulate Mr. Annamalai and his team for holding such congregations. I wish him and his team the very best in his future endeavors. But before I cede the space to Mr. Muralidhar, there is a cartoon that we put in the quarterly bar review, which according to me says more than words which any one of us could express. So this cartoon has its genesis in something that a cartoonist by the name of Bill Malden drew in 1968. And it's evidently that Gandhi and Martin Luther King are supposed to be in heaven, and Gandhi says to Martin Luther King, who was a great admirer of Gandhiji, the odd thing about assassins, Dr. King, is they think they have killed you, by which he meant our thoughts, our methodology of dealing with violence. These are aspects, even if you assassinate these people, will stay with people at large. Thank you for your patience.
For your presidential address. And now I call upon Justice Muralidhar to speak on Mahatma M.K. Gandhi, the barrister, and his life as a lawyer.
My dear friend Rajiv Shakdher, former Chief Justice of the High Court of Himachal Pradesh, Shri Ramchandra Rahi, Chairman, Gandhi Smarak Nidhi, Shri Sanjay Singha, Secretary, advocates Komal Vasishta and Ram Sherawat, Farhad Abbasi and Vijay Kumar, and all the other friends who've assembled here, lawyers and distinguished members of this assembly. I'm so happy to be invited to deliver this lecture on Gandhiji's life as a lawyer. I must straight away confess that despite having read so much about Bapuji, it was not until Charles DeSalvo brought out his book, and I deliberately brought the book for all of you to see. Those who've not read it yet, it's a must read. You can get it on Amazon. It's called The Man Before the Mahatma, M.K. Gandhi, Attorney at Law. And I will, during the course of my lecture, dwell on this attorney at law. This was the very first book that spoke elaborately about Gandhiji's life as a lawyer by looking into the newspaper archives of South Africa. As all of you are aware, the collected works of Mahatma Gandhi run into 100 volumes, 100 plus maybe. And many of those volumes do contain some of the letters that have appeared in the South African press, but nobody had examined those papers to bring out Gandhiji's life as a lawyer. So this was the first proper attempt at doing that, and this was in 2012. I had already become a judge by then, and I was completely blown, because this is something that, had I known of as a lawyer, I think some of the doubts that we had as legal practitioners may have had answers. Which is why I urge every young lawyer, or lawyer, even a middling lawyer, to read this book. Based on what DeSalvo did, Annamalai made a yeoman effort, and he has brought out another publication under the aegis of the National Gandhi Museum, which says Gandhi the Lawyer. And what is fascinating about this book, although it draws a lot on DeSalvo's book, is that it has a wonderful introduction by none other than DeSalvo himself. And it has very valuable documents. So they have Gandhiji's admission to the inner temple in London, also the resolution by which he was removed, and the resolution by which his membership was restored, much later in 2008. And it also has some of the rare appearances of Gandhiji in a Kathiawad court way back in the late 1900s, so 1800s, and other photographs and documents that give us some insight into his life as a lawyer. And of course, we have this wonderful little book brought out again by the Gandhi National Smarak Nidhi, which is The Law and Lawyers. This, many people I'm sure have a copy of. It's not at all expensive. You can easily keep it as just like your CPC, CRPC, or now what you should call as BNSS or BSA and all that. You should keep this handy for any doubts you may have as what you should do in a given situation as a lawyer. So if we want to begin at the beginning, and much of it is something that all of you know, is that Gandhiji was not a graduate. So even when he was pursuing his first year of a degree in Samaldas College in Rajghat, he did not show much interest in studies. And his father had been a Diwan. Shri Karamchand Gandhi had been a Diwan of Rajghat. So the ambition of Gandhiji's elder brothers was that Gandhiji would, somehow be able to serve in some similar capacity. And they debated amongst themselves as to what would be the best professional course that he could take if he were to reach that. And so, under advice of one Shri Dave, who was a family well-wisher, the suggestion was made that Gandhiji should pursue the bar at law course in England. And unlike what used to happen, what has happened later, this is not a university and there are no big exams. It's a series of 12 dinners that you have to take. And you write 2 exams, one in Roman law and other in English law. Roman law is considered to be a relatively easier topic, so you take it in the first, after the first 7 or 8 dinners, and the English law you take last. Gandhiji was a matriculate. His English was fairly okay, but not very good. So when he lands up in England, and this is 1891 that we are talking of, he has to teach himself not only English, but he also teaches himself Latin. He takes tuitions for these things. He understands the English etiquette, because through those dinners, your etiquette is actually looked at, watched at. He looks at the way the barristers dress, behave, but also is interested, drawn to the vegetarian society. The movement for vegetarianism was already on the ascent in England at that time. To cut a long story short, he masters both Roman law and English law. He delves into all these texts. Snell's Law of Equity is one thing that he writes about, that he enjoyed reading. And he masters Latin, and is able to read the texts. So he passes those exams, but his mind is already itching to come back to India. So it is said that it was on 10th June, 1891 that he's admitted to the bar, and he chooses the inner temple, which is perhaps the most expensive of the inns. You have Gray's Inn, you have Middle Temple, and you have Inner Temple. And on 10th June 1991, he's called to the bar. 11th June 1991, he's sworn before the High Court. This is all in London. 12th June 1891, he's on a boat to India, desperate to come back home. Now, the scene in India was very different. So, of course, there were courts, but not welcoming of Indian lawyers and not ready to give Indian lawyers work. Also, he realized that he hadn't really studied the Indian property law or the Indian family laws, personal laws, which is what most of the litigation was about. His brother worked in a court in Rajghat, his brother Lakshmi Das, and he was doing some pairvi. But the idea was for Gandhiji, because he was a barrister now, to go to the High Court in Bombay. In Bombay, he finds nobody is there to give him work. He keeps religiously going to the High Court there. There is a funny passage, both in My Experiments with Truth, which all of you have read, which is reproduced in DeSalvo's book, that he used to doze off with a gentle breeze coming in from the Arabian Sea, sitting in the High Court, and he almost thought it was a privilege to be dozing off as a lawyer. So there was hardly any work, and he was getting frustrated. Even then, he realized that there was a system of touts. So we are talking of 1893. It's a bit depressing to know that in 2025, the scenario is not very different, particularly in the courts of the districts. Unless you have contacts, unless you have references, you don't get work. This is something that Gandhiji realized very early on. So he was going nowhere. He was a barrister at law, but in Bombay High Court, those days, the arguing counsel were all English barristers. The judges were English judges. So the English barristers had a better audience before the English judges. Indian barristers didn't stand a chance. And there was a division between solicitors and advocates. That system continued very long, and today also there are remnants of it both in Bombay and in Calcutta. People who choose to write the Law Society exam in Bombay and are solicitors don't cross over to become advocates. Even today you will find them sticking to briefing advocates to argue cases. So Gandhiji was told the solicitors are all going to be English people, and they're hardly likely to brief an Indian barrister. So he realized he didn't stand a chance. Frustrated, he comes back to Rajkot. There again, he helps his brother in drafting petitions, but he realized it's a very closed system, and you have to find your way through it. It's all very frustrating, because there were 2 merchants who went from Porbandar, that very area, to South Africa. They were Muslim merchants and doing fairly well. Through contacts, they got to know that one of them wanted help in a case which was pending in Pretoria between two Indian merchants. And an inquiry is made that we want a young lawyer who can help us translate documents, because much of those documents were preserved in the Gujarati, they were memons. So that's how he goes there. He goes to South Africa. So he lands in South Africa on April 19th, 1893. And 25th May, he sets sail on April 19th, he lands on 25th May, 1893. And within a few days, Dada Abdullah, who is the client, who receives Gandhiji in Durban, takes him to the Durban court. And Gandhiji is wearing a turban, and he enters the court and occupies the horseshoe. Many of you have seen the horseshoe in many of the courts. Even today in Bombay High Court, Madras High Court, you will find the horseshoe. So he goes and sits there quietly. Then somebody goes and whispers in the magistrate's ear, there is this Indian colored person coming here into the court wearing a turban. So the magistrate sternly looks at him once or twice. When he finds that Gandhiji hasn't taken the message, he asks the usher to go and evict him from the court. And Gandhiji is told, you can't sit with a turban. So this is the first humiliation he faces in the South African court. And his protest because the press covers it. The local press finds that the magistrate has become, over fastidious on something like this, and actually comments negatively on it. Gandhiji writes a letter to that newspaper, and that's how those documents are all accessible even now in those archives of those newspapers. When he goes to Pretoria, there is a time of 1 month's gap. Gandhiji studies accounts. He gets into analyzing complicated accounts that are maintained in partnership firms of those times. And he persuades the parties to go for arbitration. Although the case is set down for hearing, they go for arbitration. Gandhiji's client succeeds. So the basic case was that one firm had purchased the branch office of Gandhiji's client, Dada Abdullah, in Transvaal. You should realize there were two provinces that Gandhiji moved between. One was called Natal, which is where Durban is, and south of that is Transvaal, which is where Johannesburg and Pretoria are. So the case is happening in Pretoria, which is the headquarters. In fact, you should be interested to know that today if you go to Pretoria, you will find that the North Block and South Block of our Lutyens Delhi are replicated there in Pretoria, because it was the same architect, Lutyens, who also designed those buildings. So in Pretoria, he persuades the clients, both are Kachi Memons, and he can speak Gujarati. He's just young as 24 years old, but he's able to convince them to go in for arbitration. His client, Dada Abdullah, wins the case, gets an award by which the other party has to pay him something like 37,000 pounds, which is a huge sum of those days. Now, Gandhiji could have gloated, could have felt, that we won a great case, but he realized that, these are two Indian merchants, and the business of the other will sink if this award is actually enforced. So he persuades his client to agree to installments. So this is that famous passage where he says, his first attempt at mediation succeeded. And, he says that everyone is better off when you succeed in mediation. There are only winners and no losers. So at very, very early age of 24, he demonstrated a streak for doing complete justice in a case, which is remarkable, because he had no role models in South Africa to look up to. And this is something that he came up on his own, which shows his innate quality of bringing about, peace between two warring factions. And that strength, of course, he developed on, and he's become an international figure, inspiring so many movements all over the country, all over the world. And I'm going to speak something about that as well. His task was for 1 year. In fact, when they invited him to South Africa, they said all this will be over in a year, and you can go back home. So in fact, they gave him a farewell in Durban, saying that I'm going back. This was 1894 May, at which time the new law was passed, proposed to be passed. It was still a bill which would not give Indians the right to vote. It would completely exclude him from the right to participate in the local administration. So because of the local merchants knew of his capacity as a lawyer and his capacity to write petitions, his letters to the editor, drafting and all of that, he had already demonstrated his skill. They said, can you stay back at least for a month to help us out with this while we petition the British government? That's how he stays back. And that 1 month becomes more than a year, and he stays on in Durban. While in Durban, he takes on cases of indentured labor. In South Africa at that time, there was a tussle between the Dutch settlers and the British. And there were Dutch merchants who wanted to monopolize commerce, and there were Dutch farmers who wanted indentured labor. So there was already a tension between the South African farmers and the South African tradespersons. And that's how, while on the one hand, they wanted labor from all over the world, there was a resistance to labor coming in and staying on for long. So there's a great control on the rights that you would recognize as being available to indentured labor. Now, many of them were ill-treated because they came in through employment contracts and not really formal contracts. They were beaten, they were tortured, they were cruelly treated, very reminiscent of what is happening to Indian labor today in the Middle East. Or, you know, the persons who take the donkey route, of which now a film has been made, who go at great risk to their own lives and are treated miserably in countries abroad. This happened even way back with our indentured labor. In fact, the trilogy by Amitav Ghosh is worth reading on how plantation workers came from India into the West Indies, in South Africa and other parts of the world. So he represents the cases of these indentured labor. You will find in De Salvo's book, and which has been reproduced in Annamalai sir's book, that among the early cases he represented was one Balasundaram, who was a Tamil indentured labor. Balasundaram was beaten black and blue, bleeding from the head, and carrying his turban in his hand. And that becomes proof of the torture that he suffered, which is preserved by Gandhiji as an astute lawyer, presented to the court. And it is sure that he will win in the criminal case. But Gandhiji realizes that this is a case of livelihood, and that a local white employer will not treat him as badly as a South African employer. So he negotiates again and gets that change approved, transfer of the license from one employer to the other. Gandhiji's ability to do this, to see beyond the result of the case, and to see that by merely criminalizing a social evil and getting a punishment, you don't resolve the issue at hand. Something similar to the Protection of Women Against Domestic Violence Act. This is something that we've criminalized. We permit a woman to complain to the police against domestic violence, but once the person is placed in jail, we're not ensuring she gets her maintenance. So it's a disincentive for a woman suffering domestic violence to make a complaint unless she is economically secure. So this disparity is something that I think in the law, probably Gandhiji recognized very early, that you have to ultimately answer the need for the person's economic security. So this is a learning that you find as a lawyer he does throughout his life as a lawyer. He deals with cases of rickshaw pullers. So from going as a lawyer for wealthy merchants, Indian merchants, the man's attention has already turned to the working class. And he's able to immediately identify with their problems. And he does all of this with next to no remuneration. He handles cases of hawkers. In fact, even today we are dealing with cases of hawkers in the high courts and the Supreme Court. Some of these problems, I think lawyers who are working for these difficult causes, you should read these books, at least these three that I have pointed out to you, because it shows why it is important to engage with the law. He was practicing at a time, there were no high courts which had writ jurisdiction that we talk of now. There was no question of challenging the validity of a law, the constitutional validity. We're talking at a time there are no written constitutions. So the only hope you had is somebody getting booked one of those laws, and you're going and actually defending the person in a prosecution. And through that prosecution, demonstrating that the law is unjust. There was no other option. But Gandhiji found other avenues. When a bill would be tendered for approval to the British Parliament, he would start writing a petition pointing out why the law was unjust. So this aspect of advocates writing petitions to Parliament, persuading them not to pass a law, is something that we need to learn. See, the American Bar Association, for instance, has a committee of advocates to study every bill that is tabled before the US Congress. The American Bar Association then gives its comments, its responses, and then that is taken seriously by the US Congress. Here we have no such system. Look at even the Supreme Court Bar Association here. We don't have a select committee of lawyers to examine every bill that is tabled in Parliament. Why don't we do that? This is something that lawyers must do. They must take that additional interest. There are many lawyers who are sitting in Parliament. It would be easy to get a copy of the bill from those lawyers who are already members of Parliament. We should be able to form our committees, give our expert comments. You have lawyers, some former judges appearing before standing committees. But that is after it has reached Parliament, after the Speaker has referred the matter to a standing committee. And as you know how standing committees work, it's by invitation. You can't just go and say, I want to appear before a standing committee. So I think this is something that we learn from Gandhiji's work as a lawyer, that he took upon himself this arduous task of carefully studying a bill, analyzing its clauses, and seeing its impact. See, this impact assessment is something that we don't realize. What will happen if this is put in force? On whom will the burden fall? How will it inconvenience the person? If you study the petitions that he's drafted, it's a wonderful piece of analysis of a fine legal mind. In fact, what people don't realize is he took his law profession very seriously. He was an expert in law of contracts. This is something that people will not associate with Mahatma Gandhi, correct? He was an expert in commercial laws. He understood accounts, he understood finance, he understood society, because he directly dealt with people of the working class as well as the merchant class. He was dealing with tradesmen, he was dealing with hawkers, he was dealing with rickshaw pullers. So, you know, the practice is so enriching. It introduces you to your whole community from top to bottom. And it's a wonderful opportunity, therefore, for a lawyer to let themselves get into society, which is what the distinction we need to draw between law as a career and law as a profession. And I keep repeating this. The choice for some of us was very clear when we entered the legal profession. For us, it was a profession, right? It was an opportunity to serve. You do get paid in that bargain, but you also get respect. That coat, that gown, that band is a privilege that's conferred on you, because you're given the privilege of taking people's problems into your hand and help them navigate through the complex legal system. And they place so much trust in you. The legal profession is the only profession where the client is shown a blank piece of paper by the lawyer and asked to sign, and the client signs, even today. That much trust a client has in a lawyer, he's expected to have that trust. The lawyer simply shows him a blank vakalatnama and says, sign here. He puts an X, he signs. Many of them sign without reading. Many of your clients don't know English and expect you, trust you to correctly present their case before the court. That kind of a trust must be earned, right? Can't be commanded. And to earn the trust, you must be able to immerse yourself in society. If you don't become part of society, understand society's problems, and understand problems from the perspective of the client. The client expects you to translate the problem into a case that can be presented in court, right? It's like the legal jargon that we use. The client is not aware of that. In fact, if you see the perplexed faces, I think we both have had the opportunity to do it for more than a decade. You actually see perplexed look on clients, because from, you know, when you sit in the dais, you can see all the clients. You can see the anxious faces that they have. And they're urged to speak to the court. The lawyer is there in front of us. Behind the lawyer, I can see the gesticulating client. He's desperate that the lawyer has not got it right. He wants to come and explain, right? So the trust a client places in the lawyer is immense. And a lawyer like Mahatma Gandhi should be the role model. Never betrays the trust of the client. And also never lies for the client. This is a wonderful combination of, you know, how to navigate this difficult path. So in many an instance you find, if he finds that his client is dishonest, he will not pursue the client's case. It requires a lot of courage You will say, sir, if I don't take up this man's case, there are 10 lawyers waiting to take up his case. Gandhiji's answer would be, let them take up that case. You don't take up that case. Why? Because you will be one of those lawyers, let's say in Tisasari, when a client enters the bar and makes inquiries around the table, who you think is an honest lawyer, they will give him names of honest lawyers. That's the beauty of the bar. Because you develop your reputation by word of mouth. Not just among clients, even among lawyers. So today I enter the Karkarduma bar and I ask some 2 or 3 lawyers who is good in cross-examination criminal trials. They'll give me names of some lawyers. Even a crooked client wants an honest lawyer. The crooked client does not want a crooked lawyer. So this is something that we don't realize in the bar. So you don't present to the court everything that the client wants you to do. Mahatma Gandhi's cases, his clients are all on full display here in this book. I would urge you to read it to see how he negotiates this difficult task, not compromising on his duty to the court, which is to present the truth, at the same time not compromising on the case of his client. It's not an easy task. It can come through experience, through years of experience, and through the respect you command from 2 ends. From the end of the client, who will listen to you because you're a lawyer who knows the system. You're not a lawyer to do his bidding. You should command that respect. And respect of the bench. Once the bench knows that you're not a lawyer who will mislead, they begin to respect you. So in this book you find Gandhiji loses cases more than he wins. Let me tell you very clearly. He loses cases more than he wins, but doesn't lose an inch of respect from either the client or the court. And that's what puts him on a high pedestal among that bar, among that population of Indians. So this is something that we need to understand as persons belonging to a legal profession. If it's a legal career, yes, in 5 years I should have a Mercedes-Benz, in 10 years I should have a penthouse, in 15 years I should reach the Rajya Sabha. You can have that kind of a path laid out for you. But if you want to be truly in the legal profession, and that's what Mahatma Gandhiji's life tells us, you have to earn the respect of not only the clientele, but the bench as well. And then, that reputation is something that becomes unshakable, that can't be taken away from you. So in Durban, therefore, he spends almost till 1901 dealing with all these difficult cases, Dealers License Act, and so on. And then decides to, I'm cutting a thing short because we don't have too much time, decides to come back to India. So between 1901 and 1902, he's back in India. This time his experience is not so bad. He is able to earn money. He is able to get clientele. But then the call comes back from South Africa saying we desperately need you here. And that's how for the second term he goes back. But this time he decides to abandon his practice as an advocate in Natal and go to Transvaal, which is where Johannesburg and Pretoria are, as an attorney. So this word attorney at law refers to how he was called in Johannesburg, whereas actually he is a barrister. Because of the rules of admission to the bar in Johannesburg, being hostile to people of color and of being barristers to be admitted as advocates, he strategically decides that if he has to fight the system, it's better he does it as an attorney. Among the test cases that he takes up as an attorney is simply a person who cannot appear in the High Court there, but can appear in the other courts, the Magistrates' Court and courts just below the High Court. One of the first test cases he takes up in 1906 is that of tram cars. This was the time when electric tram cars were introduced for the first time in Johannesburg. And even with stagecoach, horse-drawn stagecoaches, there was a kind of segregation. But here the local council in Johannesburg made it clear that there will be European cars and there will be colored-only cars. In the European cars, if there was a colored person who was the servant of the European, he could accompany his master, but not otherwise. So this was clearly a humiliation, it was discrimination. This was a time when there was no Article 14. I want you people to remember this. But this is a time when there was one lawyer with a conscience who had a deep sense of injustice stemming from the way he was treated at Pietermaritzburg. that racial discrimination which he felt on that night when he was thrown out of the first class compartment stayed with him. So he was a lawyer who could identify injustice. And that is what we want lawyers to be. Lawyers should have the ability to identify injustice, injustice done to any human being, right? So injustice not done only to the Muslim, only to the Hindu, only to the Sikh, only to the Christian. No, injustice is injustice everywhere. So his clientele was wide and diverse. There were Parsis who were clients, Hindus who were clients, Muslims who were his clients. In fact, I don't see how a professional, whether a doctor or a lawyer, can be anything but secular. In legal practice, you have to be secular. You can't say, I won't defend this client because he's a Sikh. I won't defend this client because he's a Muslim. I don't think that option is available to a true professional. If you look at this as a career of my prospects, you know, whether this will increase my prospects of progress or decrease my prospects, you start calculating, then you cease to be a legal professional. You see law as a career. That's how you find en masse resignations, right? Panel lawyer for government A has to resign when the government goes. New panel. So all party members will be given, party members who are lawyers from that party will be given all those positions. We've reduced the legal profession to this. And we've not protested. We're very comfortable with this idea. We say, acha, apna bari aayega. Ab inki bari hai. So, you know, this thinking has got into our system, which we need to get out of. Where do you get inspiration? Many people ask me, sir, who should we have as role models? One role model is certainly this man. Patel, Sardar Patel is a role model. Rajendra Prasad is a role model. Baba Saheb Ambedkar, they are all lawyers too. Rajendra Prasad was a young lawyer who assisted Gandhiji in the Champaran Satyagraha. He went to the bar in Patna and asked for assistance from the lawyers there, and of the few who volunteered, one was Babu Rajendra Prasad. This man was so inspirational. And fortunately for us, because of these written works, he will continue to inspire. But we must read. We must read, we must feel disturbed, we must want to be influenced. If we are indifferent, of course, nothing can happen. If somebody gets tortured and killed in police custody in Tamil Nadu, as a lawyer here, it must prick your conscience. Somewhere it should prick your conscience. It must do something to you. We quickly go to see, acha, what is the name of the person who got tortured, right? And we react differently if you use this name or that name, this locality or that locality. Injustice is injustice everywhere. So the lives of these great people tell you that this is how they approached their profession and what they saw as service to the society. And there was no question of putting yourself before the case. So there is a case where accounts have to be presented before the court in an arbitration case, and there is an error in the debit entry and credit entry. Gandhiji is briefed a senior in the High Court. In the conference, and I'm talking of this is of 1908, in the conference he tells the client, you know, this we have to point out to the court. The senior disagrees with him. He says, unless the court points it out, why should we point it out? Gandhiji says, no, we should point it out before they point it out. Before the other side points it out. Our case becomes weak if we don't point it out, the other side points it out, the judge will never be with us. Look at the man's thinking. And this is what happens. He gets up, he points it out to the court. And finally the court agrees with Gandhiji, it was an inadvertent error and not a deliberate suppression of fact or a deliberate manipulation of the record. So this is the short-term gains that lawyers resort to and how it proves to be counterproductive. Like in the first court of first instance in the trial court, we say, okay, let us suppress this document because today we're going to get an order in our favor. Not realizing this will be the reason for it getting set aside in the High Court. It is of no gain to the client. But we tell the client, aap jeet gaye. Hai na? So this is another thing that you learn through this man's life as a lawyer. I'll talk about other cases, but the triumph segregation. So what he does is a very interesting use of the law. So there are two laws in operation in Johannesburg. One is the segregation, that as a colored person you can't enter the European tram car. But there is another law, which is a traffic law, saying no conductor can refuse entry to a passenger who wants to board the bus, board the tram car. So Gandhiji deliberately asks a wealthy Indian businessman to board the European car. First day they don't notice it. Second day they say, no, you're a colored person, how can you? So Gandhiji then makes it sure that he goes and files a complaint and that it becomes a case in court. So very often we say, but chota mamla hai, chhod do, let's not make a big case of it. But he makes it a case. In the court, during the trial, he demonstrates to the judge that while it may be a violation of the tram car rule, which means a colored person can't enter a European car, European only car, it is a violation by the conductor of the other traffic rule because he prevented a passenger from boarding the bus. So they fine the conductor, they convict the conductor. And this happens for a second consecutive day. In the court, they try to demonstrate that this rule has been changed, and Gandhiji is able to show this rule has been changed, backdated, just to cover this case. So the magistrate again agrees with Gandhiji. The third time, the authorities get smart. They say this is the traffic rule that is getting us into trouble. We'll repeal the traffic law, which means he can't succeed in those kind of cases. But what it does is, it's the front page of the newspaper. He's already generated a public opinion about the unjustness of the laws. And he's performing in public. So through the Transvaal cases, you find the man performing in public, using the court as a platform to, demonstrate the unjustness of the laws. It was not about winning and losing cases, but using that space constructively. So he would deliberately ask people to violate an unjust law, go for trial, make a statement in court. So 2 or 3 times he has to make a concluding argument statement. He will use it to say what is wrong with the law. He knows the press is in the court. He knows they will report it to the press. He knows it will be read by the population. So this is an interesting use of court space. And this is at a time there are no written constitutions. Today we say court is a democratic space, right? When we bring forth cases. This is at a time when there's a hostile environment. The judges are against you. Worse still, the laws are against you. Your opponents are all of a different race. And you're one or two of the few colored lawyers, colored meaning lawyers who are Asians, who are practicing in those courts. And so against the entire hostile system, you have to stand, you have to make your case, you have to survive to see the next case, and you can't lose hope. So this act of using the law to demonstrate its own unjustness was a novel way of protest, which Gandhiji was a pioneer in. And we're talking of 1906, 1907, 1908. What this would later turn into is quite something remarkable. The whole civil disobedience movement, where we refuse to follow an unjust law. And as a bar, as a population, we will write about it, we will generate public opinion, and we will protest. Protest need not happen only in the streets, it can happen only even through courts. Not by gerawing courts, not by shouting slogans inside the court, not the way we do it now here. This is unruliness, doing it in a very civil way and using that opportunity afforded to you to make your statement about the unjustness of the law. Among the cases that he dealt with was also cases of people having to compulsorily register. They had what is called the Asiatic Registration Ordinance. In the first time it was enacted in 1906, he could go to London, and look at the remarkable strength of the man. He could go to London, stay there, camp there for 1 month, write petitions, meet people there to get them not to agree to approve it. It's like going to the Rashtrapati Bhavan and asking the president not to sign, right? Something like that. So his standing in the Indian community goes up tremendously. But the same law is soon enacted in the regular parliament in South Africa, and he's not able to do much about that once it's made a regular law. Unlike now, where we have constitutional courts where you can challenge the validity of laws, that opportunity was not there. So the next thing was to invite prosecutions under the law. So people crossing over from Natal to Transvaal had to show the proof of registration. So he does a series of these cases. In some he succeeds, some he doesn't. But then he shows people how to use the law, how to use your forensic ability to to point out loopholes. So there are two kinds of defenses he usually takes. One is to look for the procedural loophole, natural justice. You've not shown the material. I'll just read one such case, which is of Ram Sundar Pandit. This is a priest. I'm talking of early 20th century, which is happening even now. We have a whole army of pandits from India going to perform pujas in all our temples and households abroad. So Ram Sundar Pandit was one such pandit who came from India into South Africa to do precisely that. He was so enamored with Gandhiji's powerful rhetoric and speech, and he was an excellent speaker. So initially, although he had big stage fright, by the time he reached South Africa and he started addressing the Indian community, he was a wonderful orator. So Ram Sundar Pandit was one who was taken up with it, and Gandhiji urged Indians not to register. So if they had registered, not to renew the registrations. So Ram Sundar Pandit's permission to enter South Africa, it's like our green card or a visa or something like that, or permanent residence permit, which is not renewed. So in the cross-examination of the registrar, this is what Gandhiji elicits from him. That registrar, whose name is Montfort Chamney, says, I consider he is desirable, that is Ram Sundar Pandit is desirable, so long as he continues to preach his doctrine, but if he preaches other doctrines, I will not say sedition, and resorts to methods for inciting his people to violence, he becomes a person other than the one I understood as allowing to enter this colony. Basically, he's trying to say Ram Sundar Pandit is another person among your ilk who is persuading people not to register, so you're doing a political act. Now, Gandhiji says, how did you determine that he was, a person preaching other than religious doctrine? He asks, you have just said that you had grounds for believing that he was preaching other than religious doctrines. Have you sufficient grounds for that belief? Our whole administrative law today is based on this. Valid grounds, materials. I have had complaints both from white and colored people, says that person. Have you ever warned him with reference to those complaints? Certainly not. When did you receive the complaints? I cannot remember the exact dates, but it was in respect of registration of Asiatics. Can you produce the complaints? I will certainly not. The allegation of sedition affects the case very closely, as it is a serious matter to bring a charge of sedition against my client. Then the court interferes to say, Mr. Gandhi, the matter of sedition will not affect the case materially. Gandhi says, justice to my client. The complainants referred to be produced. So then Gandhi says, Mr. Chamney, you positively declined to produce the complainants? And he says, yeah, positively declined to disclose. So through this process, a simple but very profound point is being made, which is violation of natural justice. This is a magistrate's court. Skillful art of cross-examination to bring out the point. The magistrate there, of course, still doesn't relent, because he's a magistrate of that regime. He's already got his bias against the Indians. So he still goes ahead to convict, but lets off with a very light punishment. But the point is, it's carried in the press. See, today if we have this entire dialogue, it is because it is reproduced verbatim in the press. The press is very interested with this one Indian lawyer, who seems to have forensic skills, who's able to demonstrate the unjustness of the law or of the system. He's demonstrating in one shot the unjustness of the law, the unjustness of the person who's enforcing the law, who will not show the material against the person to that person, the unjustness of the judge, who will not take this seriously and, acquit the person. So in one stroke, the man is using the court premises to demonstrate injustice. And that is quite remarkable. Unless you have strong convictions and strong mettle, see, you will lose cases in court, but still make your point. And it is all done with quiet dignity. In fact, throughout you find people referring to the way he speaks, very soft-spoken, but very profound. So this is something that, impresses me even today as a person who's been with the law for almost 4 decades. It's a remarkable use of the court space. I know I'm running out of time. So in 1911, he decides to wind up his practice, by which time he set up both the farms there, the Phoenix farm and the other one, and Tolstoy farm. and he decides to come back to India, but ultimately it takes him 1914 for him to reach India. By this time, he's also himself violated the law, courted arrest. So he's arrested twice in 1908, once in 1909, once in 1913 in South Africa. So he's already understood the value of civil disobedience, how it can be used as, a political instrument to make people who are otherwise, adamant and stubborn, and to make them listen, to shame them into saying, yes, there is something wrong with the law. So when he comes here, of course, he plunges. He's the one person who travels third class throughout the country, changes his attire, transforms himself. So the person practices first before he starts preaching. When people say change should begin with you, this man actually practiced it. He actually changed himself, got to know the people. So traveled the length and breadth of the country in train in third class. And very early on developed the habit of walking to court. Whether he was in Bombay or in Rajghat or in South Africa, would always walk to the court and walk back. That's how he remained so fit. If Dandi March happened in 1930, what is the fitness of this person we are talking about? Remarkable. A 61-year-old person, swiftly walking, how many? Almost 90 kilometers, is it? Yeah. So there are many lessons, and I'll stop here. First, and this is important for the lawyers to know, despite difficulties of being placed in a hostile system, one should not give up. Even when the system and law is against you, and there is no support from the bar or from the people whom you are fighting for, one must keep working with perseverance. In today's time in India, this is very, very relevant for every young lawyer to know. We've all had difficult cases. I used to constantly appear in the Supreme Court in my earlier phase for convicts on death row. And the chances of success was very remote. I was already appearing for the Supreme Court Legal Services Committee, and it would be concurrent judgments of the trial court and the high court, and the crime would be a heinous crime. And here I would be struggling, first on merits and then on sentence, trying to get death sentence commuted, and maybe I succeeded in terms of percentage, not even 20% of the cases. So every time my colleagues, when we came back after that verdict was pronounced, would all feel depressed, naturally. We would have worked so hard, we'll feel depressed, and they'll ask, sir, why are we doing this time after time? What is the point in doing all of this? Then I'd say that, if I move away, if I say that I'll stop taking these cases, this is one lawyer less for that cause. And we don't want less lawyers, we want more lawyers for such causes. I must share with you that having come back to the bar, and I'm sure Justice Shakdher shares this view, it's encouraging to find a young band of lawyers who are equally committed to the cause. They're prepared to work pro bono, they're prepared to put long hours, they're not deterred that the case is a hopeless case. We say no hopeless case, you have associations, bar associations passing resolutions that nobody from this bar will represent this person. It's totally unethical. It's contrary to the professional ethics. And we have this happening time after time, which is unacceptable. Just imagine if all the surgeons aides say, if a person accused of a terrorist crime will not be treated in our hospitals, will it be acceptable to all of us? Certainly not. If we say a person accused of rape will not be provided medical help, certainly not. You do your duty as a professional. Leave it to whatever has to happen to the other, the judge will deal with your argument. The judge will determine whether he is guilty or not. You don't take the mantle. If lawyers become judges, what remains of the system? So don't give up fighting for a cause just because the environment is hostile or the law is hostile, or even you don't get any support from your own bar. Second, there can be no excuse for lack of professionalism. Gandhiji was an expert in drafting and learnt it the hard way. His advice, especially for lawyers, was the same advice that he received: be clear about the facts, the law will take care of itself. The man was very particular about stating facts, but stating facts in a very precise, terse manner, not lengthy pleadings. He realized that having lengthy pleadings actually distracts a judge, and while drafting documents, that they should not say anything more than what was necessary. And this is very important. These are Gandhiji's words, by the way. use of adjectives in legal documents never serves the cause and purpose of the document. You know, you take a 498A complaint, the number of adjectives that we use doesn't serve the cause. If that person who's supposed to have said those things is put in the box, he'll say, Vakil Saab ne bataya, aur mujhe sign karna pada. So lawyers don't realize what harm they can cause to their clients. And this is something, as a professional, he advises, which advice holds good, I mean, universally and eternally. Third, Gandhiji demonstrated the power of the pen and documenting, which each lawyer must realize. Especially lawyers working in PIL cases should document meticulously, make available material to the public use, regardless of outcome. A lawyer working on the same case sometimes in future must have the opportunity to learn from the mistakes that the previous lawyer made while fighting the cause. Now, this man wrote in the Indian opinion, young Indian. Out of his own funds, he started these publications. He is a man who earned very well in the profession. He had a flourishing practice in South Africa. He had a firm with several of his young colleagues who were all white South Africans and women assisting him in the profession. Yet he set aside some part of the earnings, not only for those two farms, Phoenix and Tolstoy farms, but also for Indian opinion. And in India, when he came, young Indian. So much of the writing that you find in Law and Lawyers and all of that comes from these two journals. And he meticulously recorded everything that happened. That's how you have 100 volumes of the collected works. So this documentation, this reading, understanding and writing, which we advise every young lawyer to do, every young law student to do, this man practiced throughout his life. Even after he stopped professional practice, he continued maintaining journals, continued recording what was happening, and continued recording the mistakes he was making. So today it's very easy for us to analyze Gandhiji's mistakes. We say, oh, he went wrong here, he had that prejudice, he had this prejudice. You actually see the evolution of a human being because he's bearing his soul to you. He says you discover the truth not only about yourselves, about the world, about life, but even about me. He says, I was not this perfect human being to start with. I was a human being with so many imperfections. The title is Experiments with Truth, right? You can find numerous faults with a person in his personality. But you can find those faults because he's laying it bare before you. Which other statesman, which other leader in public life has the guts to do it, you tell me? Not a single leader today has this guts to say everything that is happening in his life. So it's very easy for us to judge off this person saying, oh, he had these problems, these weaknesses. But what we fail to realize is as he was struggling with arriving at the truth, he's taking you along on that journey. If you're willing to know. So this is something that is remarkable about this person. Fourth, learn from experience. Failed cases are more important than those that are won. Gandhiji learned more about the law from the cases that he lost, and he used these failures to develop as a lawyer and drew strength from them. Gandhiji would use the court as a place to challenge the unjust nature of the laws, not only as a place for wins and losses. While making a speech in front of the judge, he not only realized when it turned political, but also knew how to leave an impression in the mind of the judge. Fifth, stick to your principles and ethics. So there is a case about a person who's an Indian merchant who brings in goods into South Africa, some of them smuggled in, bypassing the customs. His fortune or misfortune is that he finds Gandhiji as his lawyer. And when Gandhiji knows it, he says, you better confess and pay the fine. Otherwise, I'm not taking your case, you can go somewhere else. It's a change of heart in the client. And he precisely does what Gandhiji tells him to. And is eternally grateful to him for the rest of his life, as these papers tell us. Stick to your principle and ethics. Gandhiji firmly believed in being truthful and never compromised on that. An honest lawyer further inspires his client to indulge in only truthful and ethical practices and is always respected for the same. There is a special place in the bar for honest lawyers, and they are widely known for their righteous way to fight a case. Sixth, using the test case strategy, the tramcar case that I talked about. This is earlier to the civil rights movement in the US. If you remember, the civil rights movement spearheaded by Martin Luther King Jr., they used the bus segregation as a test case, right? They had Rosa Parks, a black woman, sit in the space reserved for the whites and invite prosecution. Likewise, in 1961, which is much after Brown versus Board of Education, they, what do you call, like, occupied public libraries which had segregated spaces and invited prosecutions. So this way of, inviting prosecution through the law was started by Gandhiji in South Africa, which became a model for others to follow. So now you have, for instance, Greta Thunberg gets onto a ship to go to Gaza, and she's stopped by the Israeli authorities. They don't manage to reach Gaza. But look at the publicity it gets. It demonstrates how unjust this whole action against people peacefully protesting is. So you have, for instance, the Jal Satyagrahas of the Narmada ousties. It attracts attention. It somewhere makes the person who's in administration feel uneasy. And that's what you want. Irom Sharmila, 12 years on a fast. Right? These are all people who've taken inspiration from this one man who says, don't give up and do it peacefully and do it through your own instrument, which is your body. So this fast unto death, this, refusing to obey the laws, inviting the harshest punishment, what Rajiv just now read out, this is something that he told a judge in South Africa. So the precursor to this was that. He said, you've given all of them punishments, give me a harsher punishment. Because I was the one who asked them to do it. So the judge is shamed into, being just. There are so many kinds of protests that we have around us, around the world, but much of this is inspired by the non-violent means that one person introduced to the world, and that was Mahatma Gandhi. I can go on, but I would urge every young lawyer in the audience to read one of these three, and preferably all of these three books, and get inspired by the life of Gandhi as a lawyer, and improve ourselves as human beings. Being a legal professional is not only about winning and losing cases, but winning on the side of justice. Be on the side of justice. Thank you.
Yes, Justice Rajiv Shakdher. So, thank you, Justice Muralidhar, for your wonderful discourse on Gandhi's experiments with the law. So, thank you. I request you can leave. We will continue, and I'll ask Sanjay Singh to propose the vote of thanks.
Thank you, Dr.S. Muralidharan ji, for your remarkable speech, and Sri Rajiv Shakdher ji. So, I think, sir, Gandhi ji will be remembered for the justice, the rights, and the peace work. Even though many people said that his spirituality and the experiment in the field of spirituality will be remembered years after years. But the fighting against the injustice, for the rights and the peace, it will be remembered. But situation is this, sir, when the law and the lawmaker and the law enforcers are the same person or one or two persons. So then there is a great threat in the judiciary system or the justice system. जब कानून बनाने वाला और कानून लागू करने वाला एक हो या एक और दो व्यक्ति हो जाता है, तो पूरी व्यवस्था को लिए खतरा होता है. इसलिए ये चिंता की बात है. पर ये समझता हूँ कि गांधी जी ने अपनी पूरे कानून की पढ़ाई की जो ज्ञान है, वो अपनी आज़ादी के आंदोलन में उसका भरपूर इस्तेमाल किया. ब्रिटिश लॉ को बहुत अच्छे से जानते थे. ये भी जानते थे कि किस कानून को तोड़ने में कितने साजा है. और एक ऐसा वकील जिसको आज़ादी के लिए, न्याय के लिए, अधिकार के लिए और शांति के लिए आने वाले हजारों वर्ष याद किए जाएंगे. उनके खास करके न्याय के लिए जो संघर्ष के विचार है, उन लोगों को प्रेरित करता रहेगा। मैं वकील नहीं हूँ, लॉ भी मेरा फील्ड नहीं है, इसलिए कितना ये उपयोगी रहा ये सत्र, मैं उसके लिए मैं चाहता हूँ कि एक हमारे बीच में जो लॉयर है योगेश जी, उनको आमंत्रित करूँगा कि वो 1 मिनट में आके बताए कि आज का सत्र कैसा लगा और क्या है। उसके पहले मैं आभार व्यक्त करना चाहता हूँ नेशनल गांधी म्यूजियम के सभी कार्यकर्ताओं का और गांधी शांति प्रतिष्ठान, गांधी स्मारक निधि के सभी लोगों का, और ख़ास करके आज हमारे बीच में आप सब लॉयर, सीनियर एडवोकेट्स, हाई कोर्ट से, सुप्रीम कोर्ट से और दिल्ली के अलग अलग कोर्टों से जो लोग आप सब लोग आए हैं, इस परिसर में आप सबका स्वागत है। हमारी लाइब्रेरी है, बहुत बड़ा लाइब्रेरी है, आप लोग आइए और इसका इस्तेमाल कीजिए, इसको अपना परिवार समझिए। और गांधी जी एक बैरिस्टर थे, एक वकील थे, आप सब भी वकील है, इसलिए वकीलों के साथ हम लोग हमेशा एक अच्छा रिश्ता महसूस करते हैं और हम मानते हैं कि हर वकील के अंदर कहीं ना कहीं एक गांधीवादी तत्व जो है वो मौजूद होते हैं। आप सबका स्वागत। और मुरलीधरन जी, आपका हम विशेष आभार व्यक्त करते हैं क्योंकि बहुत ही शानदार रहा आपका आज के भाषण। योगेश जी।
Thank on behalf of all our advocates here. And sir, we're learning, we'll be calling you in different lectures. I thank all my colleagues, senior advocates, all those who had participated in this program, all those who supported us for this event. And sir, I would also like to thank our Annamalai ji, who had for once thought, if this is the thing, let us go ahead. Thank you so much. On behalf of, I'm a part working with children, sir. We are working for the Constitution, basically. We are inspired by the Constitution. We have some books to present you on behalf of Jawahar Balmand, sir. So please give us the opportunity. I'll call upon Vivek ji, I'll call upon Pawan ji to come forward. I will call upon Shabir bhai to come forward to give this book.